Thanks for joining us, everyone, today. I'm Catherine Barona with Levelset, and I work on the community engagement team with construction lawyers and connecting construction lawyers all over the country with contractors and construction professionals. And today we have Mary Salamone from Procopio. She's based in Orange County, California, and she'll be presenting Essentials of Record Keeping and the Overlooked Key to Project Success. So I will let Mary get started now, and she can further introduce herself. Thanks, Mary, for being with us. And one other thing, if you have any questions at any time in the presentation, just type it in the chat box or the Q&A panel, and we'll be sure to get that question over to Mary. All right, thank you.
Thank you, Catherine, and good afternoon, and welcome to everyone, and thank you for joining us today for this informative webinar. I'm just going to start by giving some very brief background about myself, I guess just to give everyone some level of confidence that I may know a little bit about the subject on which I'm speaking today. I've been practicing exclusively in the area of construction law for the past 33 years. I've had the privilege to represent all participants in the construction industry, from both public and private owners, general contractors, subcontractors, designers, and even suppliers. I actually cut my teeth in this business, starting by representing suppliers on collecting for materials using the various statutory remedies like mechanics liens, stop payment notices, and payment bond claims. But I think this varied background gives me a unique perspective when I'm trying to resolve disputes. I've been recognized by both Chambers USA and Best Lawyers in America as a leader in my field, and I also serve as an arbitrator with the American Arbitration Association. I sit on their large complex construction disputes panel, and I'm also an arbitrator with the Office of Administrative Hearings, the Public Works Contract Arbitration Program. Today's webinar addresses the essentials of record keeping. Far too often, I have found that a party's failure to keep proper and accurate records results in needless problems on a construction project. I hope that you will be able to take away from this seminar a few good practice pointers to implement in your day-to-day construction operations to avoid some pitfalls. And with that, let's jump into the materials. Now, to just quickly highlight, these are the topics I intended to cover today. The importance of project documentation, uncovering best practices for record keeping, understanding written notice requirements in contracts and why they're important, protecting change order claims. I'm going to discuss statutory release forms and their effect on lien rights and other statutory collection remedies. And then I'm going to wrap up by talking about the significance of making sure that you are properly maintaining your contractor's license status. Now, why do we have to keep records at all? I mean, I think we can all agree that it is painful to have to do that. I know as a lawyer, I have to be diligent and meticulous about my record keeping, and it takes a lot of time out of the day, but it serves some very important purposes, particularly on a construction project. First off, records are necessary for just effective contract administration. They also promote the continuous monitoring of project status and facilitate day-to-day management of a project. They can also be used as an aid in the early identification of problems and assist later in the investigation and resolution of any subsequent claim or dispute. They're also particularly vital in the event of turnover of project personnel. This industry is kind of prone to people coming and going to different companies. And if the person you had in charge of a project, everything they know about that project was up in their head and none of it is documented anywhere, when that individual goes, and particularly if they leave on bad terms for some reason, they take the corporate memory with them, so to speak. That's another reason why it's important. And then just lastly, written documents are given more weight in a court of law than what a person's memory is given in determining what actually happened, because we all recognize that our memories just fade over time. And sometimes before these cases get to a court, the project may have concluded 4 or 5 years prior to that before somebody is testifying. So none of us have impeccable memories where we can remember those types of details, and that's why having records becomes particularly important. So the next subject I want to segue into is just some record-keeping guidelines. Obviously, the picture you see is a situation that we'd like to avoid on a construction project. So when you are keeping records, you want to make sure that letters or emails, any type of communication is clearly written and is easy to follow. You always have to bear in mind that at some point, somebody who may not be familiar with that project may read those records. In other words, if you're in court, a judge or a jury may end up having to look at these documents as exhibits, trial exhibits, or even in arbitration. So you have to make sure that they're easily understandable. They need to be contemporaneous record of events that are prepared in a timely manner. You don't want people going back writing about what happened three weeks prior or 3 months prior. And they should be compiled by the person with direct knowledge of that event. And they need, again, to be sufficiently detailed for a third-party understanding. And you should determine an organizational system in advance, for instance, creating tracking logs for requests for information, change order requests, submittals, things of that nature. I represented a client a number of years ago. They were a general contractor, and they did mostly industrial type work. And I went in, and they were having some claim issues, and I discovered that their record keeping was just abysmal. They weren't even keeping tracking logs of change orders that subcontractors were submitting to them, and the change orders to the owner weren't getting tracked in any way. And it was so bad, actually, they lost the estimate for the project even. So I tried to gently discuss with them the fact that you've got to keep some organizational structure to these types of records. It's going to be the key to your success. They kind of scoffed at my advice, and a few years later, they basically had to close their doors in California because they were just hemorrhaging money on projects. Continuing again with some record-keeping guidelines, you want to be factual with whatever you're writing. You need to be extremely careful of giving opinions or what I'll call editorializing. That's very dangerous. You want to state things that you can prove, you can demonstrate. It gives you more credibility. You also want to reference any underlying contract provisions, specifications, and the like to support the position you're taking, whether it be an email, a letter, etc. And you want to make sure you're avoiding personal attacks in any colorful language, always asking yourself, would I be proud of this document if it were a trial exhibit? I know sometimes things can get pretty contentious on these construction projects, and 4-letter words may abound on a job site, but it doesn't mean they should find their way into written communications, though I have seen that happen on a number of occasions. And I just think in front of a judge or a jury or an arbitrator, that type of verbiage, terminology doesn't necessarily reflect well on the individual author. And you want to be careful, as a final note, of what I'll call marginalia. And what do I mean by that? That's just a fancy legal term. It means the little notes you may write on the margin on whether it be meeting minutes or a letter you got. You want to be careful of those types of notations because they can all get discovered if you get into litigation. And if you get into litigation, there's no such thing as a personal file. All that becomes uncloaked. So you have to be very careful about what you're writing. I remember a case I was handling once, and my client had taken a position in a letter to the owner, and somebody on my client's staff had disagreed with that position and wrote a little note in the margin that said, "This is total BS. I don't know why we're saying that." Well, we got to litigation, and out comes this notation. Not particularly helpful. Now I'm going to segue to talking about correspondence and emails and some helpful hints in dealing with that type of record keeping. First off, you want to use a single reference line when possible, one subject matter when possible. And it just makes matters easier to retrieve when you're looking through hundreds or thousands of emails to find an email you recall writing. If you're writing about different subjects and you're never changing that subject line in the email, it's going to become much more difficult to find the needle in the haystack. You want to relay the circumstances and the reason for the communication, and you always want to have a backup of all that electronic data, and you want to store it off-site. You need to caution folks working for you that storing things solely on their laptop without backing it up on a server is unacceptable practice. I've heard stories about laptops being left in trucks, and the laptops, the truck's gotten broken into, the laptop's been stolen, and now all of that information has been erased because it was never backed up. Also, hitting a delete button on the computer does not mean it's gone in today's technology. There are these computer forensic folks that can track down this information. You will be surprised. And again, never assume any emails are private or confidential unless they're being exchanged with your lawyer. Do not say anything in an email you would not want someone else other than the recipient to read. I have found that with the advent of emails, this boundary that people used to observe between the written and spoken word is often lost in these emails. So conversations that I would dub like water cooler type conversations are finding their way into emails where they would never have found their way into written letters. Let's talk about notice requirements. You need to make sure you're very carefully reading your contract, because I have yet to see any construction of contract with owners that doesn't require some written notification being given by the contractor. And often that notification must be followed by things like detailed schedule analyses or submission of costs and supporting documentation and the like. And you have to make sure you're strictly complying with those notice requirements. California is pretty strict about compliance, not as strict though as other states back east, but still they're not going to allow you to utterly waive notice requirements and fail to adhere to them altogether. I've listed here just a few types of notices that can be given. And again, as I said, failure to provide that notice to an owner could constitute a waiver of rights by the contractor, because it's denying the owner an opportunity to conduct an investigation and to actively participate in some potential resolution. One of the more seminal cases I just want to highlight for everyone to kind of drive home the point about the significance of notice is this Gregopinski Construction versus City of Oakdale case, decided 2011. Just very quickly, these are the highlights of the facts of that case. The contract required a written change order for all modifications to price or time. The contractor was required to submit any request for a time extension within 30 days after that triggering event, and the contract said no extensions would be valid unless they were made in accordance with the contract. The contractor completed the work late. The city assessed liquidated damages. Contractor argued it was excused from the notice requirement because it was the city that caused the delay. Well, in that case, the court held because the contractor failed to give a notice of any delay claim in accordance with the contract, it barred any defense based on the city's alleged fault. And as a result, the court upheld the assessment of liquidated damages, and the court refused to consider any evidence that the timely performance was rendered impossible by the city. I want to talk next about daily progress reports, because I cannot emphasize enough the significance of maintaining these. Because when Humpty Dumpty falls off the wall and the project is miserably late and there's cost overruns and we're trying to figure out who pushed Humpty Dumpty, the first thing the consultants I hire want to look at are things like daily progress reports, because they are supposed to tell the story of what happened on the project contemporaneously. While you should record weather conditions, that's not all you should record. Far too often, all I see in these daily progress reports are things such as sunny and 75. Well, we know most of the time in Southern California that is the weather. There's many other things you need to be reporting, and this is a list of just a few of them, so I'm going to highlight some of them. But you want to always talk about any problems or difficulties you may have encountered in the site. You want to note any significant conversations or instructions you received maybe while you were on the site. You want to record any safety inspections and accidents and any controversial matters that arose. Continuing on, another very important thing to document is progress information, such as quantities installed, delays, action taken, actions contemplated. You also want to make sure you're recording labor information, the number of workers on site by trade and the specific area they're working on. I remember I was representing a general contractor on the construction of a very large hospital project that was delayed. And we made a very concerted effort to work with the subcontractors to create a site plan that divided it in various grids and told them, if you're working in this section, this is A1, this section's A2, this section's A3, et cetera. When you're on the second level, it was B1, B2, B3. And that was distributed to the subcontractors to get everyone on the same page, so we were very clear where they were working on a given day. Otherwise, we would have no idea where they were working on a very large hospital project with multiple floors. And wrapping up on some daily progress report items that should be documented is you want to prepare these on a daily basis. You want to prepare them at the time the events occur. For the same reason why I made that comment about some of the other record keeping is that you want to do it when your memory is fresh and you recollect distinctly what occurred. And again, objective commentary only. This is not intended to be a Dear Diary. I was working on this was, again, a cancer center project, a little different project than the hospital I referred to. And on that one, the subcontractor had created volumes and volumes of handwritten daily reports. And the judge was, on that, I had the owner and contractor who teamed up against the subcontractor on that project. And the judge was so thoroughly impressed at the thoroughness of these. But when you delved into them, you had the superintendent making comments about their claim and that it was meritless and that they were grossly exaggerating the changes that had been made, on and on and on. At the end of the day, I believe their claim was about $2.5 million. I got a defense verdict. They were awarded nothing. The next set of documents that are, again, keenly important to try and tell a story of what happened on the project are photographs and videos. And it brings back the old adage, a picture speaks 1,000 words, and it truly does. You want to take pictures at regular intervals and at milestone dates. You want to take them at each elevation, north, south, east, west. When you're doing so, though, you should identify a precise location and date you're taking those photos that will help support the progress schedule. Today, a lot of folks are using webcams. Again, great, helps you document what's going on in the project, where people are working on any given day. Helps you record, bad soil conditions and poor workmanship and the like. In the event you're ever terminated for default on a project, you want to make sure you get in there and you're either videotaping or taking lots of photographs. So now we're going to segue to, again, another form of record keeping, and it relates to project meetings. Now, there's numerous types of meetings that are held on projects. You have meetings with the owner and architect team. You'll have meetings with subcontractors. You may have dedicated meetings to talk about schedule. You may have dedicated meetings to talk about change orders, et cetera. But generally speaking, there should be procedures implemented for these meetings, or it's going to become a free-for-all. So it's preferred if you conduct these meetings at the construction site, if at all possible. You want to have kind of a standing date and time for those meetings so everyone has it on their calendar. You want to prepare an agenda to organize that meeting and distribute it beforehand. And you should designate a chairperson that's going to take control of that meeting and make sure the discussion is on track. And I know in today's technology it's very difficult, but you want to try and limit distractions, as people getting on their cell phones or having sidebar discussions. And then you want to identify, discuss the issues, and agree on a course of action. Then after those meetings, minutes are typically circulated of what took place. And in those minutes, you want to identify areas of concern or problems. You want to identify action items with a responsible party, and very importantly, assign a deadline. to tasks. Otherwise, they'll just linger. You want to prepare those, circulate them promptly for commentary. And I always suggest that you volunteer to maintain the minutes. Again, I know it's added work, but you control what's said if you control those minutes. And I always tell people, if it isn't written, it wasn't said. That's why it's important to see if you can control the drafting of those meeting minutes. I'm going to talk about schedules just quickly because we could spend hours talking about schedules, but typically on any construction project, you're going to develop what is called the baseline schedule from which you're going to construct the project, and that will serve as kind of the measuring stick for any delays. So when you prepare that baseline schedule, these are just some of the reviews you should conduct to make sure that the schedule is complete and adequate for your purposes. Then as you go along, I think you all should be aware already that you have to update that schedule typically on a monthly basis. And it's very important to update your schedule because it will help you plan the work. And as this little cartoon shows, miracles do not happen. So you have to manage the schedule. So as to these schedule updates, you have to make sure you're using them as a planning tool and not a billing tool. Far too often I see contractors just submitting these to get paid, and they may state a certain amount of work has been accomplished when it hasn't been accomplished. And I just don't think that's to anybody's benefit to do that, because sometimes you're pulling the wool over your own eyes when you engage in that type of practice. So if you're adequately monitoring your schedule, you should start recognizing problems before they really become of critical concern. And you should always be careful to monitor, is work being performed out of sequence? Are you having to change logic? And are you consuming float? And float is that additional time you have to complete the work before that activity is falling on what we call the critical path of the project, which means it controls when the work is ultimately done. So by monitoring that schedule and accurately reflecting what is going on that project, you will have a better command of the construction project. Now I'm going to turn to a discussion about change orders. As I say here on the slide, barring miracles, change orders are just a fact of life, and these are just a few of the reasons why I believe that they're an inescapable fact of life. Every project is unique. It's never been designed or built, and a drawing is a small-scale representation, and it cannot reflect the full detail of work. And I know if we have any architects or engineers on this webinar, you'll be stunned if I say that architect, engineering, and design are not exact sciences. And so there's the possibility of error. And then you have, if you go in and you alter one detail in one area, this could have a ripple effect and affect countless other detail sheets and components. And then you just have the reality of sometimes you're just going to encounter differing site condition on the site. You may encounter utilities that weren't shown, soil conditions that were not known, et cetera. So it creates the need for change orders. What you have to hope is you're not in this situation where the value of the change orders now is eclipsing the base contract. And change orders just have a very bad reputation in the construction industry. This little picture describes the contractor's perspective of himself, but I think this picture more adequately describes the owner's perspective of a contractor, where they feel that the project may be getting underbid, and the contractor is just going to, as they say, change order them to death, and make up what they may have left on the table in change orders. So owners are not very receptive to change orders. So you have to make sure that you're being meticulous in how you document that changed work and how it's getting priced. So a few words of caution on that subject. You just want to generally avoid any verbal orders or directives for extra work. In particular, when it comes to working on public works of improvement, those verbal orders are not binding on any public agency. So if the public owner's representative comes to you and says, yeah, go do that work, I promise you I'm going to pay you for it, that promise is not binding on them. There's been a reported case where even when the owner's representative stated and testified under oath, yes, I directed that work and I told them I would pay for it, because those oral, verbal type instructions are not binding on public agencies, the court wouldn't allow the contractor to recover because he did not adhere to the contract requirements for change order work. You want to track labor and material costs on a daily basis, and at a minimum, you'd want the owner to at least sign and verify crew size, equipment on site, and the hours worked. If the owner wants to dispute entitlement, that's fine, but at least you want at the end of that workday or the very next morning, get the owner's signature on like a time and materials ticket acknowledging at least the crew size, the equipment, et cetera, because you can have the entitlement dispute later, but at least the parties then have an agreement on quantification. And do not execute change orders if you believe there's any schedule impact. Look for it. If there's 0 days that the owner's inserted, you may want to change it to the wonderful acronym TBD, to be determined. And then I want to wrap up a change order discussion, just calling some attention to certain waiver and release forms that owners may tend to use. This image I know is hard to see, so I'm going to blow up the language that's at the bottom in the fine print. As a lawyer, my eyes always get directed to the fine print at the bottom of a document. That's usually where the bombs are buried, and certainly that's where this language is contained. I simply blew it up at the bottom of the document. And it's release language, is what we call it in our industry, and starts off just fine by saying, by signing the change order, the contractor acknowledges that it's been fully compensated. But the problem starts when it says that you're acknowledging you've been paid for all impact, ripple effect, or cumulative impact on all other work under the contract. And the reason why I call this potentially dangerous language to your attention is if you have a project where maybe each change is not of such significant magnitude, but you have hundreds of them, to the point where you get into that situation of that other picture I showed you where the number of change orders ends up eclipsing the contract. And the industry dubs that a death by 1,000 cuts. I don't know if any of you have heard that expression, but it's an expression that's often bandied about in our industry. If you find you're getting into that situation, you don't want to be signing change orders that has that verbiage on it, where it talks about ripple effect or cumulative impact on other work. The concept is that a large number of changes not only affects changed work, but can start affecting work that wasn't changed. And it starts releasing productivity claims, loss of efficiency claims, and things of that like. So let's transition now to talking about statutory release forms. In the state of California, the law restricts the types of waivers that can be signed in exchange for payments received on construction projects. And there are statutes that are contained in what are called our civil code in the state of California that prescribes 4 different release forms. And the law says that those forms must substantially follow the statutory language that's laid out for them to be enforceable. Those forms are basically a conditional waiver and release on progress payment, an unconditional waiver and release on progress payment, a conditional waiver and release on final payment, and an unconditional waiver and release on final payment. So there's 4 of them. And only by the use of those 4 forms that substantially follow the statutory language can any claimant in California be deemed to have released mechanics lien rights, stop payment notice rights, and payment bond rights. Having said that, signing those forms does not release any claim for breach of contract that may be asserted. It just releases the statutory remedies that are provided in the state of California to assist you in getting paid for work performed. Now, as I mentioned, there are 4 release forms. But they can be bundled into 2 forms, one a conditional release form and the other an unconditional release form. Each of these pertain to whether it's a progress payment or a final payment, and that's how you get 4. But talking at a higher level about a conditional release, those depend on the payment of money. So without the actual payment of money, that release has no effect. So that is the type of release typically you're either going to provide, whether you're general to the owner or whether you're a subcontractor to the general contractor every month in order to get paid for that month. You do not provide an unconditional progress payment. That release is only provided once you have been paid and you have confirmed the funds have cleared the bank. If you provide an unconditional release form and you have not been paid, there's no attorney that's going to be able to save you from that, because the law says your lien claims are extinguished. Now, having said that, it doesn't extinguish necessarily your breach of contract claim, but your statutory remedies, the mechanic's lien, the stop payment notice, the payment bond remedies, those are now gone. So let's look real quickly at just a couple examples of these forms. Now, this form mirrors the statutory language that has to be used. Just as a footnote to everyone, in 2012, the California State Legislature decided that they were going to go in and overhaul these statutory release forms and revise them. So if you have release forms that you kept in your drawer and you just keep Xeroxing, if they don't bear a date after 2012, you should probably dispose of them. And these forms are readily available on the Internet. The Internet's a wonderful thing. And you can download these from the Internet. This particular one is a conditional waiver and release on progress payment. And what I've done is just blown up the language that's in the highlighter at the top of the form. And it tells you right there that this document waives lien, stop payment notice, and bond rights, and it's effective on receipt of payment. A person should not rely on this document unless satisfied that the claimant has received payment. Also, I want to call to your attention some additional language towards the bottom of the form under the header exceptions. This was verbiage that was newly added by the legislature in 2012. Make sure when you fill out this form, you're also completing this portion as well, so it's very clear what date this release goes through and the amount of unpaid progress payments that still remain. Now I wanted to just show you by way of comparison the verbiage at the top of the unconditional waiver and release on progress payment form. I'm going to blow it up for ease of reading. And it says, this document waives and releases lien, stop payment notice, and payment bond rights unconditionally, and states that you've been paid for giving up those rights. This document is enforceable against you if you sign it, even if you have not been paid. If you have not been paid, use a conditional waiver and release form. So it's cautioning you right here that if you've not been paid, you should not be using this release form for that particular month. And then the last topic I want to touch upon is a discussion of contractor license laws. In the state of California, your license that you've been issued by the California State Contractors License Board, that's the little icon you see on the right. They go by the acronym CSLB, is basically good for 2 years, and the license expires on the last day of the month when it was issued. And you have to make sure that somebody at your office is calendaring that expiration date. Now, the CSLB does send a renewal notice approximately 60 days before expiration, but if you've moved offices and if you've not notified the CSLB, your license may expire before that notice catches up with you if you haven't also calendared a reminder to yourself. So with the wonders of Outlook, it's very simple to make sure that that date is placed on your calendar so it does not pass you by. Now, who needs a license in the state of California? Well, you need a license if you're working on construction projects that are priced at $500 or more in both labor and materials. And no, you cannot break the project down into little $499 pieces to avoid the licensing law. And you cannot charge an hourly rate to try and get around the law either. And what is below is an excerpt from the Business and Professions Code where the legislature has defined what a contractor is. So if you fall within that definition you see on the slide, you better make sure that you have a license. Well, why is that so important? Why does Mary keep telling me over and over again that I need to make sure I have a license, I need to make sure that it's active and in good standing? Well, if you perform work and you don't have a license, you're subject to civil and criminal penalties for that, such as 1 year of imprisonment, which I'm sure nobody wants to happen. You're also precluded from maintaining a lawsuit to recover compensation for work performed. But just when you thought that was bad, folks, it gets worse. You're subject to what is called disgorgement. And that word sounds ugly because it is ugly. And it's just a fancy legal term for meaning to the extent you performed work when you weren't licensed and you were paid by whether it be the general contractor or the owner for that work, they have the right to take back whatever you were paid for that work. Even if there was no issue with the work you performed, there's no claim that it was defective in any way, and even if the owner knew that you were not licensed at the time of entering into the contract, there's a case right on point in that regard where an owner admittedly knew that the contractor was not licensed, and the court did not care. There's such a strong public policy behind this principle that the courts are extremely harsh and draconian in their enforcement of these laws. And I'll tell you just a very quick story. As I mentioned earlier in my introduction, I'm an arbitrator with the American Arbitration Association. And a case came before me. I was on a panel with 3 arbitrators, and one of the parties was seeking to disgorge from the mechanical subcontractor $12 million for work on a project that was performed without fault, without issue, and the general contractor had no dispute with the sub other than that general contractor happened to discover that there was a licensing lapse. And that lapse could be even as short as 1 day. Doesn't have to be weeks or months. 1 day of a lapse is all it takes. And the mechanical subcontractor in that case tried to make an argument that their situation fell within what is called the substantial compliance doctrine, which meant they had to demonstrate and satisfy these 3 prongs: that they had been duly licensed prior to the performance of the contract, that they acted reasonably and in good faith to maintain a proper license, and they acted promptly and in good faith to remedy the failure upon learning of the failure. Well, this particular mechanical sub was licensed at the time the performance began, but at a period of time they lost their RMO. They did not replace them in a timely way where there was a lapse in the license. And the panel I sat on found that the problem was the contractor did not meet number 3, and you have to show all 3. That's why I have and in bold and caps and underlined on this slide. They could not satisfy that 3rd prong of this test. We ordered that that mechanical subcontractor return $12 million to the general contractor for not being properly licensed. So I give you that example to highlight the significance of the licensing laws in the state of California. And on one final note on that subject, you should be aware that was a recent case just decided, as you should see here, August 26th of 2020, so just a couple months ago. The legislature had never given us guidance on what the statute of limitations was for somebody to go back and try and disgorge money. I've heard stories of very large general contractors in the state being sued 7 years after they completed a project by an owner now trying to seek disgorgement. So finally, we've gotten some guidance here from a court recently that imposed a 1-year statute of limitations which accrues or begins to run from the completion or cessation of the performance of the contract. So that is certainly helpful now that this is a 1-year statute of limitations, and will hopefully stop people from trying to go back years after the fact to disgorge monies paid. So with that, I have a few minutes left for any questions you may have. Catherine, I don't know if we've received any questions.
Yes, we did, Mary. Thank you so much for that presentation. That was excellent and very helpful and informative. So there is one question from Tiffany. How can material providers protect themselves when customers file a credit card chargeback after the 20-day delivery period?
I'm not sure I'm understanding that. The 20 days, I'm assuming, is being referred to, the 20-day delivery period. I think what is being referred to by Tiffany is, in California, there's what used to be called a 20-day preliminary notice. And if you want to make a claim on a project, meaning record a mechanics lien or serve a stop notice, you have to serve a preliminary notice. And that 20-day preliminary notice is typically served within 20 days of your first furnishing labor and materials on the project. And it reaches back 20 days and reaches forward for forevermore. So if you're continuing to provide materials and you hadn't gotten that notice out, you should immediately send it out, because it's never late. It's just going to control how far back it reaches. So I'm not sure I'm understanding her question entirely, but tell you what, if Tiffany or others want to contact me, that's my email address. You can reach out to me, and I can maybe probe a little further as to what exactly that question is. But if you serve that preliminary notice and an owner paid, and then or your customer paid and then tried to reverse the payment, you have the right to put a mechanics lien down on that project. You have a right to serve a stop payment notice on that project, and that's why those statutory remedies exist, is to protect you.
Okay, we have a few more questions popping up. And Brian asked, how do subcontractors use the prime contract to enforce payment or the receipt of a formal change order?
Well, I would have to look at your subcontract to see, did the provisions of the general contract flow through to you? But if you've not been paid and you're trying to enforce payment, you have a number of what I'll call arrows in your quiver. One is just a routine breach of contract cause of action or lawsuit against the general contractor. But then you also have these three other remedies we've talked about. You have a mechanics lien right if it's not a public work. You can't lien public property. So you have a stop payment notice right, though, on public property, which is a trade-off for not being able to lien it. And if it's a public work of improvement, you have a right to make a claim against what's called a payment bond, which is a mandatory bond that the general contractor has to post on a public work of improvement. So if it's a private job and it's owner financed, you can either put a mechanics lien down, or you can serve a stop payment notice, and you can sue the general contractor for breach of contract claims. And for the change order issue, you would have to document that there was a changed scope of work and detail what your costs were, and that's recoverable just as you could recover work you performed under your base contract. Again, if there's further questions or follow-up needed, you have my contact information. Write it down. Happy to answer questions by email as well.
Mm-hmm. Okay, we have a couple more if you have a minute for them.
Sure.
Okay. Robert asked, first, is a prelim valid when only an LOI is in place? Meaning, is the notice requirement in place when the subcontract is finally live?
I'm sorry, read the last portion of that again to me, Catherine.
Yeah, is the notice requirement in place when the subcontract is finally live?
Yeah. Speaking of that preliminary notice, you can never serve it too early. So if you're saying the preliminary notice was served when there was just a letter of intent, but then at some point later the contract becomes, I think the terminology that Robert used was live, it's actually going forward.
Mm-hmm.
You can never serve that preliminary notice too early where it's premature and it's invalid. Having said that, though, you would want to make sure that you still have all the accurate information about who the owner is, who the general contractor is there a lender involved or not, and you would want to verify that once the contract becomes live, because sometimes some of that information, like about a lender or something, may change potentially. But it's not as if your preliminary notice is rendered invalid as being premature in some way.
Okay. Great. Thank you for that. And Tom says, I'm a telecom material supplier, and a lot of our products are now being installed on utility poles in the public right of way. What's your thought on how to secure ourselves with these going forward? 2 million light pole will have this equipment in the next 5 years.
Well, again, if that pole is public property, you can't lien it, but you would have payment bond rights and stop payment notice rights. If the utility pole is private property, but it sits on public land, I'm not sure what good a lien on a utility pole is necessarily going to do. I mean, it kind of, I guess you can liken it to a little bit like a landlord-tenant scenario where you're doing some, TI work, and the owner is posted what's called a notice of non-responsibility, and what you may end up at the end of the day is a lien on a leasehold interest, but not on the land itself, which is not nearly as meaningful as having a lien on the land itself. But again, keep in mind that there are options here beyond a mechanics lien, like a stop payment notice. If it's owner financed, it can be served directly on the owner. If there is a lender involved in the financing, for the stop payment notice to be binding on the lender, it must be accompanied by a bond that you would need to get from a surety. You do not need a bond if the project is owner financed. And then again, there are also these payment bond options. If it is a public work of improvement, they're mandatory, where you can seek recovery.
Okay. Sounds good. Thanks for that informative answer.
Sure.
Charissa asks, what is the best practice for documenting change orders?
If I'm assuming that Teresa's with a company that's performing the work, typically what I would tell you to do is if I have an owner or if I'm representing the general contractor, I typically don't like to see just lump sum change orders. You would want to see a detailed price breakdown of those change orders, breaking out labor hours, hourly rates, equipment costs. You need to be putting on the general contractor on notice that you deem this as a change in scope. You don't want to do what you believe is changed work and then come back later with the surprise, here it is. You need to be sending written notice that it's a change in scope and making sure you're getting written direction to proceed nonetheless. And then you want to give that detailed pricing. I believe the owner, they're entitled to it, as opposed to lump sum pricing. And then you want to see if you can negotiate a price for that work before it's performed. Unfortunately, I don't know, this industry has just kind of changed so much over the years. 9 times out of 10, parties don't agree on a lump sum change order value before that work is performed. So I would tell you the safe harbor practice is, if you don't have a lump sum change order amount agreed to before the work is being performed, but you're ordered to perform it and your contract requires that you proceed, you should be keeping time and material tickets, again, recording the actual costs rather than some forward-looking cost, and getting those signed off on at the end of each workday, and maybe using that method to get paid. It depends on what your contract says. It may say that is the method you will use if you can't agree on a lump sum change order. But again, that goes back to keeping good daily reports, taking good photographs, all that type of documentation that would substantiate any change order request.
Okay. And last question here from Belen. Is there a time limit for when a contractor needs to issue a mechanics lien after issuing a prelim notice?
No. It's not as if it doesn't run from, I'm going to say yes and no. It doesn't run from when that prelim notice is issued. The time frame you have to record a mechanics lien runs from when the project is completed. It has nothing to do with when you serve your preliminary notice. on the general owner, etc. So the law says that the parties would have 90 days to record a mechanic's lien, unless, if you're a general or a subcontractor, unless there has been a notice of completion recorded. And now we're getting kind of way beyond this scope. It's an area I certainly know about, but we're kind of getting beyond the topic of the webinar. And so I'm trying to be careful how much detail I'm getting into. Unless the owner serves on all the project participants a notice of completion. If the owner does that, it shortens those deadlines to 30 days for the subcontractor, 60 days for the general contractor to record that lien. So be aware it does not run from when your individual scope is completed, though you certainly are free to record a lien at that juncture. The law puts that outer deadline running from when the overall project is completed, not when your particular scope of work is completed.
Mm-hmm.
But that deadline is not tied to the preliminary notice in any way. There's no correlation between those two things, other than you need to serve a preliminary notice in order to have a lien right, unless you have a contract directly with the owner.
Okay. Great. Thank you so much, Mary. And if anyone attending has any further questions, feel free to email Mary. And thank you so much again for your time and all the information you shared. It was really invaluable to everyone listening. I know it was helpful. So,
well, thank you very much. Appreciate the opportunity.
Thank you, everyone. Take care. And that's the end of our webinar.